So thank you everybody for joining us today. It's my great pleasure to have Enrique Prieto-Rios from Rosario University in Bogota join us today. Enrique was a former director of research when we met and for a number of years, and I believe he just recently stepped down for that big role. But he's a great researcher who's been working on a range of issues and is published quite extensively. Today he's going to talk about his excellent book on systemic violence of the law, colonialism, and international investment. I think for those who work in human rights, and particularly in transitional justice, we often are very policy, sometimes focused, in thinking about how things could work better. And I think in reading this book, you don't realize that there is almost this hidden, and Enrique talks about this sort of like this encrypted language and the way in which these international investment trade agreements work, and particularly sort of the insidious nature in which the sort of the dispute settlement system works. And I think Enrique put it quite well, and hopefully talked to today about this, almost the way these systems put like a symmetry between the rights of foreign investors with states, and it sometimes goes against the way in which we think about international law as being a horizontal system between states, and the sort of vertical dimensions between then citizens and states, or individuals or corporations with the state. So it very much shakes up and exposes, I think, both the sort of legal dimensions and the implications it can have on states and policy, as well as I like the way this historic aspect to it, in relation to tying in colonialism. It's a modern day form of plunder. So I think there's a lot of really rich thematic topics in it. So I'll hand over to Enrique now, and then we'll have some time for questions and discussion afterwards. So thank you, Enrique, for joining us today, and I'll hand over to you.
Thank you so much, Luke, and thank you all of you that have joined this conversation. So what I've tried to do, if that works, is I'll try to show some slides, then come back. But also, if you have questions, or the most important aspect for me is to share with you my thoughts, my arguments, but also to receive feedback, and of course, to have this conversation that could lead to a future or to further work regarding this topic. So let me try. I'm not very good at Teams, so I hope it really works. So again, so this is my email. So in case you just want to send further comments or questions, or just to stay in contact, that'll be great. So again, as Luke mentioned, and the idea of today's talk, a conversation, is to share with you some of the main ideas and arguments behind this book that was published last year by Roman and Littlefield. If you don't, if for some reason you don't understand, or I'm not clear enough, because of course I'm a non-native speaker, so just let me know and I could come back to something. Right, so this book, the title, as it was mentioned, is Systemic Violence of the Law, Colonialism, and International Investment. Now, the first thing that I want to say is that I didn't want this title. I wanted a more traditional title, like International Investment Law and Systemic Violence of the Law, but systemic violence. But then, after a few months of discussions with the editor, I have to quit. But then, after seeing the final or the outcome of this book, I think the title really makes sense in terms of the argument presented there. So although at the beginning I was not that happy with the title suggested by the press, then I think really now it really shows the main argument here. Now, so let me come back here. I'm just trying to okay, stop. I don't know if I'm still sharing. Nothing. I'm not longer sharing. So in this book, what I want to share is an alternative narrative about international investment law. Now, as you could see, the next question, or the next slide, was about what do we understand by international investment law, and especially when one works on international human rights, one tends to dismiss other areas of international law, especially international economic law. and also in terms of transitional justice. However, what I have noticed or what I have learned throughout this time is that international economic law has a direct impact on transitional justice, international human rights law, and even at the domestic level. In the book, I show how, for instance, in Colombia, we amended our constitution in order to reflect these kind of treaties. So this is a very important system that we need to look into and to understand. So basically, the idea of international investment law, and I really like this slide here. Let me put it here. Okay, this is again here. Okay, so when we talk about international investment law, we talk about a system, one of the branches of international law. And remember that international law is a fragmented system. Now, what this branch offers is an exorbitant protection or extra protection for foreign investors when they move from a home country to a host country. So basically, for instance, when BP moves from the UK to Colombia, then if the UK and Colombia have a bilateral investment treaty, then that British company will be fully protected or will have an extra protection. Now, that extra protection is very important because it grants the possibility of or offers the company a possibility to directly sue the host state whenever it considers that its rights and interests that are protected by this treaty have been violated by any action or omission of the state. Now, what is important to say is that so far we have around up to today 3,600 bilateral investment treaties. And those treaties have more or less the same structure. So they have a definition of who is the investor, what is an investment, but most importantly, they offer this extra protection in terms of protecting against direct and indirect expropriation. It also offers the possibility of, or the protection of the most favor, or offers the principle of the most favored nation principle, and it also offers the protection against or when there is possible violation of fair and equitable treatment. And then very important is that this system has something that is called the investment or how to resolve disputes between investors and states. Now, let me move to that part of the investor-investment dispute settlements. So, okay, so before moving there, it's something very important is that usually, or how it has been presented, international investment law is presented as an alternative for the protection of foreign companies when they move to developing countries. So this was a system that was created following a colonial logic. So in other words, when the modern system of protection of investment law started, then the logic was, okay, there are new countries that are decolonizing, and those new decolonized and independent countries are trying to take over the companies or the economic interest of our citizens in those former colonies. Hence, we need to protect them, and we cannot trust in the domestic courts. Hence, we need to come up with an alternative to protect the interest of our investors. And of course, here we have the idea of a system, right, that allows those investors to bring their claims not before the domestic courts, but before an international tribunal. And again, the main argument behind this system is, okay, this offers an speed or a quick resolution of the conflict. It allows problems of corruption and bias of domestic courts, and it also grants the opportunity for going beyond domestic rules that a lot of time may not understand or reflect the interest of foreign investors moving to a certain country. Now, so wrapping up what I have said, so international investment law appears as a response to the decolonization processes of the second half of the 20th century. Right now, we have 3,600 treaties that offer an exorbitant protection to foreign investors when moving to another country. And third, and most importantly, is that there is a system to resolve the dispute between states and states, but most importantly, between investors and state. That is the ISDS, and I will talk about that later. So, international investment settlement dispute between states and foreign investors. Now, another thing that is important to bear in mind is that at some point, developing countries started to or enter into this system because they thought, or the idea is that if you attract foreign investment, then you will increase local savings, you will create new jobs, there will be new technology, and in doing so, a developing country will reach the promised land of development, right? And as such, the idea, or this is a clear equation. So if you join the international investment law system, in other words, if you sign bilateral investment treaties, then in doing that, you will attract more foreign direct investment. And if you attract foreign direct investment, then you will reach the promised land of development. Now, that's the reason why many developing countries enter into this system. However, something that I think is important to mention is that up to 2019, as showed in the book, the home countries of the top 20 foreign direct investment home economies were, as you can see, the majority developed countries, right? So, in other words, the idea behind the international investment law makes sense when you look at this data, right? So you're a Colombian, you say, okay, if I sign this kind of treaties, perhaps I'm gonna attract foreign investment coming from these countries, right? That's something that totally makes sense. However, then the question is, if that's the idea, or the question is, does international investment law really attract foreign direct investment to a developing country? Of course, all of you that are familiar with international investment law, you know that plenty of research produced by the World Bank and by different academics around the world have shown that there is no direct relationship between foreign direct investment arriving to a country and then developing countries entering into these bilateral investment treaties or becoming part of the international investment law system. Now, moving on to my next slide, just to continue with my argument here. So, one of the things that we need to look at is the ISDS, the investor-state dispute settlement. That's one of the main characteristics of international investment law. I'll come back to this data. So this is the way how ISDS operates is different to other branches of international law. Let me explain to you why. So basically, under a bilateral investment treaty, when a country, for instance, Colombia, enacts a law or there is a judicial decision by the Constitutional Court or there is an administrative decision that affects the economic interest of a foreign investor, then if there is a treaty and then the foreign investor is protected by that bilateral investment treaty, that foreign investor could directly bring a claim against the host state, against Colombia, without exhausting the local remedies. Now, the second thing that is and this is important because, as you may know, for instance, here in the Inter-American system of human rights, if you're an individual and you want to present a case or you want to bring a claim against a state, you need first to exhaust local remedies, and then, of course, you go first to the commission, and then the commission may present your case before the court, but you need to go all through the different domestic STGs, right? And also, if you think, for instance, about the ICC, the International Criminal Court, right? So the idea is that based on the principle of complementarity, then the ICC only enters when the court or the court aims is to complement domestic justice. But usually in international law, when there is the possibility of an individual or a company to bring a claim against the state, then that entity or that individual should try to exhaust local remedies. It doesn't happen in international investment law, right? That's very interesting. The second thing that makes ISDS unique is the fact that there is not a permanent court, right? So if you think again about the Inter-American Court of Human Rights, so there is a certain number of judges sitting there for a period of time. The same happens with the ICJ, right? So we have the ICJ, we have the judges sitting there for a minimum period of time, and there is one tribunal. One could say the same thing about the appellate body of the World Trade Organization, that although it's not working right now, then the logic of having a unique court with a specific number of judges sitting there for a period of time works, and works because the idea is to avoid any conflict of interest, right? That's the idea of you having international court with people sitting there for a certain period of time. Now, in international investment law and ISDS, it doesn't work like that. First, because there is not a unique court, right? So we have hundreds of investment tribunals every year. And then the people sitting there are not always there. In other words, people sitting there are either partners or lawyers at magic law firms. So we're talking about these very famous, important law firms that are around the world. Sometimes are academics, but are people that sit there just for the duration of the process, right? So if the trial lasts for 1 year or two, that's the period during which that person will act as an arbitrator. Now, there is plenty of research that I present in my book showing that there's a lot of conflict of interest in which you have arbitrators sometimes acting as attorneys on behalf of an investor, other times acting on behalf of the state, and then other times acting as arbitrators. Now, is that wrong? Well, I think one of the main issues here is conflict of interest. But second and most importantly is coherence, right? That's another very important issue because although we know that the president does not exist at the international level, in other words, international tribunals do not create precedent, then what we know is that because there is a unique court, they tend to refer to previous cases and they try to maintain certain coherence, right? So, for instance, we see that the ICJ continuously quote the Nicaragua and the United States case and that kind of logic behind landmark cases. Now, that's not necessarily the case in investment law. Why? Because there are hundreds of tribunals with hundreds of arbitrators sitting there. And of course, what one has noticed, or what is possible to learn when you read this words, is that a lot of times, for instance, one same different claims against the host state based on the same facts are truly decided in different ways. The most clear example are the claims against Argentina. Remember that Argentina defaulted at the beginning of the 2000s. They imposed restrictions on the domestic economy, and as a result of that, plenty of foreign investors brought claims against Argentina. Argentina's main defense was they were acting under necessity, and remember that based on the draft articles, international draft articles on responsibility of the states, Article 25, then that's one way to avoid responsibility. Now, in different cases, different arbitrators decided in different ways, sometimes for Argentina, sometimes for the investors, but all claims were based on the same situation, factual situation. So that's very important. Now, let me come back here to these data. So another issue regarding ISDS is that there could be the possibility of having the word or to keeping the word secret, right? This is very interesting. So, for instance, if a country is having an ad hoc procedure with an investment arbitral procedure, and then the host state and the investors agree to keep the award secret, so then that award will never be known by the citizens, and this is very problematic because when you think about a host state, right, defending itself before an international tribunal, then you need to ask yourself, well, where does the money come from, right? And you need to think about it at the end, who is paying for the fees, right? For the attorney fees, who is paying for the compensation is the government, and the government's money come from taxpayers' money. So one might think, well, how is it possible that the government could use public money and then keep secret an award, right? So this is very complicated. But most importantly is that a lot of time there is, or right now there are arguments that ISDS does not favor investors, that it actually favors states. Now, from 1987 to 2019, there are approximately 1,023 awards or cases of ISDS cases. Now, not all of them are known because, as I mentioned, it could be kept secret. But out of those that is possible to read the result, the final award, right? So we have this data here. So if you look at, this is from 1987 to 2019. So most of the cases that have been decided have been for the state, right? So you have this data here, 246 compared to 198. So you may say, okay, well, but first, so what Enrique is saying is wrong because the data shows that usually these arbitral tribunals that are non-permanent and which there are hundreds of people tend to rule for the state. So it is good. It does not affect the interests of the state, considering that the most of the states that sign these kind of treaties are developing countries because it attracts foreign direct investment, and then foreign direct investment takes countries to the promised land of development. Now, the first question is, what about these settled cases? What about these discontinued cases? What about these cases where liability is found but not damage awarded? So usually if there is a claim, right, filed by investor against the host state, and then the investor and the state reach a settlement, it could be because there was some kind of compensation or payment made by the state to the investors. Now, one could add, right, some of these cases to, one could add some of these 139 cases to those cases decided for the investor. Although they're not awards, final awards, what is there is a payment coming from the state to a foreign investor. Now, discontinued cases. So the question is, what happens with those discontinued cases? It is not impossible, but it is not easy to find information about these discontinued cases. But the important thing is, can one think that some of these discontinued cases relate to some arrangement between the host state and the foreign investor? And one could think, of course. Now, so if we add some data or some numbers from settled cases to discontinued cases to these cases decided for the investor, then one could think that actually the system tends to rule for the foreign investor and not for the state, right? Now, another criticism that you could find here is that I'm taking a whole period, 1987 to 2019, and then, of course, bilateral investment treaties have changed throughout the time. But so they have changed throughout the time. So it means that one could say, well, countries now are aware of what's going on, and treaties have changed. Then the counter argument is that actually the system started to really work after 2002, right? And then because before that the number of cases was very small, and it is only until or after 2002 that we have an important number of cases coming before investor tribunals to be decided, right? So that is something important to know, and also that in research terms, it will be very difficult or to know whether all the states have changed their bilateral investment treaties or have a more protective bilateral investment treaties. Then it will require a further or a PhD research to look at each one of those treaties around the world. So, for instance, one may think that, for instance, well, in Colombia and in our Latin American countries, we have a fourth generation of treaties that tend to be more protective. Perhaps the same is not does not happen with the Solomon Island, for instance, right? So that's something that you could criticize about my data here. However, it's something that we could bear in mind. Now, so, and what is important is that also the majority of those cases that that either were decided for the investor or that were settled, in your words, payment given to the foreign investor, the majority have were against developing countries, right? So, and actually, from the total of 1,023 known treaty-based ISDS cases, 550 have been cases against developing countries, right? And the reason is why. The reason why is that, of course, the developing countries receive these investments because the majority of home countries are developed countries, as it was shown in my previous data. Now, having said that, then I would like to move here. So then you may see, well, okay, so Enrique is giving out some information about investment law. Perhaps all of you know about this, how it works. And well, he's saying that there are issues regarding the ISDS, and that most of the ISDS tends to be ruled against countries, and the majority of countries brought before investment tribunals are developing countries. Okay, so what does it have to do with systemic violence? Well, let me tell you that a lot. Okay, so I'm here, coming back here. Okay, so here, remember that usually when we think about violence, right? Violence, we think about physical violence, right? And we think about, for instance, the attack of one country against another, what's unfortunately happened right now between Russia and Ukraine. Or at the domestic level, when we may think about insecurity, like, for instance, you being robbed or punched by another individual. In all those circumstances, what you have is the victim clearly identified, and the person or entity that caused that aggression is also the aggressor is easily identified. Now, beyond physical violence, of course, all of you know that there are forms of violence, right? And those other forms of violence tend to be also non-physical forms of violence. And I want to focus on that. And that's what I try to tell, or the narrative found in my book. So what I say is that we need to pay attention to non-physical forms of violence. And I also, what I say is that that non-physical form of violence requires normative systems to justify the wrongdoings that are caused against a specific individual or a population. Now, of course, the fact that other forms of violence, a part of the physical violence, are less evident, right? It doesn't mean that we need to normalize that kind of violence, because, as mentioned by Luke, if we normalize that systemic violence, it deters any possibility of us overcoming that form of violence, because to overcome a form of violence, we need first to identify that violence. Now, in doing so, my argument here is that international investment law as a system, with all the taking into consideration what I have previously shared with you, that system facilitates forms of systemic violence. And let me repeat what I said before, and is that in my understanding, forms of non-physical violence or requires normative system to exist and to be heeded. So what I'm saying is, in economic terms, international investment law serves as the instrument to hide these forms of systemic violence that are affecting that affect the world in general, but specifically affect developing countries. So let me move further on this. Now, if you have the opportunity to read the book, I say that my understanding of systemic violence is the creation and maintenance of unbalanced legal, economic, and political conditions that have a direct impact on the social, psychological, physical integrity of citizens of non industrialized countries. And in doing so, it restrains, and among other things, opportunities for social improvement, economic growth, protection of environment, and culture. Now, this long thing that I define, or my understanding of systemic balance that you could read in the book, tries to identify that here what we have is that the whole international investment law exists and operates in order to maintain first those unbalanced situation between different countries, right? But also does not help to countries like Colombia to overcome social issues, economic issues, the inequality that exists here, right? That's what I'm trying to say. And and of course that systemic violence in the case or in the argument presented in my book relies upon international structures that have their own networks, ideologies, and institutions. Of course, that's what I try to present in the book, that international investment law as an instrument that facilitates forms of systemic violence against developing countries has their its own network, ideologies, and institutions, right? And here you may, and let me emphasize this before moving to your point, and is that international investment law facilitates the systemic violence because it limits the ability of peripheral countries, developing countries, to regulate matters of public interest. And we will see that in more detail later on. Also, it is very important to mention that international investment law gives priority to economic interest of private parties over the interest of the community in general. Also, very important, international investment law system, according to my book, helps to naturalize exploitation, domination, and violence in those developing countries. And that is naturalized through the discourse of development and through neoliberal ideology. However, you may also say here, and I'm moving forward here, and is okay. Just let me show some here, some data, and is, for instance, if you think about, for instance, um, these are some data about the impact of investment arbitration against African states, right? So, for instance, African states, this is up to 2020, African states have been ordered to pay investors in total $4.6 billion. And for instance, the 11% of all known investor state dispute settlement have been against the African states. 64% up to 2020 were ruled in favor of investors, right? So this is very interesting. This is updated data because my data was up to 2019. Now, also let me show you about Latin America. This data, for instance, reflects some of the most scandalous cases against Latin American countries. One of the most one of the most infamous cases was the case of Occidental and Ecuador, in which, in this case, initially the arbitral tribunal ordered the country to pay $2.3 billion, and then it was reduced to $1 billion. Still, if you look at this data, then you will see that this amount of money is a lot of money for countries like Ecuador or Colombia or Uruguay, right? So, for instance, remember that Uruguay was sued by Philip Morris for imposing restrictions on the cigarettes and the consumption of cigarettes. So this data is very important to show how this argument that the international investment law system facilitates situation of systemic violence is translated, and is translated because if a country like Ecuador has to pay $2.3 billion to a foreign investor, and that $2.3 billion represent 33% of its GDP, then you are, as a developing country, you are facing serious problems. Serious problems in the sense that that money that perhaps you could use to build roads or to do anything else in favor of your citizens or your country, then you have to use it to compensate a foreign investor. Plus, don't forget that states have to pay for the attorney's fees plus the fees of the arbitrators acting in the arbitral tribunal. Now, one thing that you perhaps could say is, well, your argument is very 90s, Enrique, because, right now there are also bilateral investment treaties between North and North countries. And you may say, well, Enrique, look at the CETA, the Canadian European Union Trade Agreement that contains an investment chapter. And of course, this is between the European Union and Canada. So yes, of course, perhaps you could say, Enrique, you're right. The beginning of this system was under the logic of North-South relationship, but it has changed. And also, you need to be aware that now more developing countries are coming up with new BIT models that try to protect their ability to regulate domestic affairs, right? Because remember that in this form, in international investment law, when the state regulates and that regulation affects the interest of a foreign investor, then at that moment is when the foreign investor brings a claim. And usually the claims are the result of the state trying to protect human rights or trying to protect, for instance, environmental law. I'm sorry. In the worst case scenario, like in Colombia, trying to move forward with a peace agreement, right? Or a transitional justice scenario. Now, you could argue, okay, Enrique, your argument is very 90s. And then my response to you that is also in the book is yes, but right now we need to also be aware that the international investment law is moving from an Eurocentric branch of public international law. It is moving from a Western Eurocentric system of law to something that, and I really like this, Fernando Cornell refers to global centrism, right? And what I say is the fact that international investment law is moving from Eurocentrism to global centrism does not affect in any form that is a system that contributes to facilitate forms of systemic violence. And here is very important because right now what we're experiencing is that companies are using their leverage with host states, right? So to persuade them to enter into bilateral investment treaties, that's one. But also companies are using their leverage, multinational corporations are using their leverage with home countries also to enter into these agreements. So how this translates is, for instance, you got, Diageo, that's a UK exporter company, then pressuring the UK government to enter or to sign a bilateral investment treaty with Colombia. And at the same time, Diageo pressures or put pressure on the Colombian government to sign this bilateral investment treaty. And at the end, what you have is the companies pressuring both countries, right? The northern country and the southern country. But what happens when you have this kind of new agreements between North and North countries, like the CETA agreement between Canada and the European Union? What we have here is that the multinational corporations are interested in creating international legal web to protect and secure their economic activity. They're no longer concerned about these differences of global south and global north. They're concerned about protecting their business. And we need to think that we're not longer in a democratic system. We now are in times an age of corporatocracy. And we're not longer thinking about the rule of law, but the rule of the market. And here, what I'm trying to say is that multinational corporations are not longer corporations that can be attached to one state, right? So, for instance, think about the HSBC, right? The Hong Kong Shanghai Bank. So, its main headquarters are there in London and the city of London. Then it is registered in Panama, but its shareholders are all around the world, right? So with those new corporative structures, what we have is that corporations now are interested not only in protecting their assets against ignorant, corrupt, and countries, developing countries, or using Keynes' words against monkeys. When remember that when he sat at Bretton Woods with representatives from Latin America, he said that he was eating with monkeys, right? So international investment law is not longer only interested about protecting civilized companies from monkey countries, as in reality is interested in protecting the economic interest of multinational corporations all around the world, right? So we move from Eurocentrism to global centrism, in which the jurisdiction or this network of international treaties could also affect developed countries. And you are aware, for instance, that Canada, under what used to be known as NAFTA, has been forced to pay many millions of dollars in compensations to American companies and so on and so forth. However, the main issue here is that although right now there is also north to north countries and also developed countries are facing the backlash of this system. And remember, for instance, President Trump saying that this investment tribunal system was not working, that he intended to denounce all these treaties and so on and so forth. Despite of that, the problem is that developing countries continue being sued by foreign investors. And the second is the majority of foreign investment around the world comes from developed countries. And third, and is very important, is that while $2.6 billion may not affect the economy of Canada or the United States, a compensation order against a state like Colombia and Ecuador to pay $2.6 billion has a direct impact and may affect the livings and the functioning of the of the state, and may stop the state complying with its duty to protect the rights and maintain the minimum living standards for the citizens. Now, I want to conclude with this. Yeah.
Sorry, I'm just conscious of time, and I may want to give some time for people just to maybe to comment, because we've got until around about 5 o'clock, but now 15, maybe 20 minutes.
Yeah.
So do you mind if I cut across and maybe open up to maybe some questions and maybe comments? Because you've covered a lot of ground there. Is there anybody who's got a question? If you want to raise your hand, I can unmute you. I think that's the best way. So, or you can put it in the chat, either in the chat or to raise your hand if anybody wants to. Okay, so hi Claire. Sorry, I'll just unmute you and oh, sorry, Declan's quicker than me. Sorry, go ahead, Claire.
Hi, that was really interesting, Enrique. I learned a lot, and there's a lot of research behind what you're doing. I wanted to ask you, bearing in mind, I know it's not the sort of level of analysis you're working at, But you're looking at states, right? The colonial relationships between states as reflected in international investment law, and thinking of Latin America and Colombia particularly, within states you have indigenous peoples who have the right to self-determination, right to prior consultation, and the principle of free, prior and informed consent. And we know that there are sort of regional mechanisms to help those sort of rights be respected and leveraged. But I wanted to work, how does that tie up with international investment law? What happens to the prior consultation rights when there is a kind of dispute? Because that's like another layer of colonial relationship. So I wonder if you could share some ideas about that, please.
Yes, thank you, Claire. I don't know, look, shall I answer straight away, or are we taking more questions? I know, how do you prefer me to answer?
Do you maybe want to answer Claire's first? I see there's another hand. Billy's hands up is next, so if maybe we'll go on that after.
Yeah. So thank you so much, Claire. And just to make shameless self-promotion, but I just published a chapter on this issue of investment law and indigenous communities in Latin America. So after this, I could share with you. That's okay. But basically, it's very important because what is happening in Colombia and in Latin America in general is that first, states are experiencing what is known as a regulatory chill. So they are trying not to get in trouble with lands, for instance, that although could be owned by indigenous communities, are right now under the administration of foreign investors protected by these treaties, right? So domestically, some countries are just trying to avoid any conflict. So basically, indigenous communities say and come and say, okay, we need the restitution of this land, and then countries will try to avoid that. That's the first scenario. The second scenario is regarding prior consultation. So prior consultation in Colombia is not, the result of prior consultation does not stop a project going on. This is very interesting because people may think that if the majority of community votes no, that's it. And then, of course, what happens is that the company needs to restructure the project, but it is not necessarily no to a project, right? So what is happening is that many companies have threatened the Colombian government that if the prior consultation is a negative, and then based on that, the country does not grant or does not allow the company to continue with that, then they will bring an investment claim against that. Third, and most importantly, there is a case of Paraguay. So there was the AXA community that brought a case against Paraguay before the Inter-American Court of Human Rights. And one of the main arguments of the Paraguayan government not to comply with or not to return the lands to the AXA community was that the lands were already occupied by a foreign investor, and that foreign investor was protected by a treaty. So in returning the land, they will be in breach of that international investment agreement. So just to conclude, is that what is happening right now in Latin America is that countries are preferring to protect the interest of foreign investors and companies over indigenous rights, and they're trying to find alternatives within the legal structure to give priority to those interests. And the reason is because they are afraid of being sued by foreign companies and paying millions of dollars. I could share with you that the chapter that was published last year in a book edited by John Burroughs, that's a Canadian lawyer that works with indigenous communities, and we present with data that the situation is very negative and that international investment law is taking priority over international human rights law. That's very complicated. Thank you for the question, Claire.
Okay. Thanks.
Billy, your hand's up next. Sorry, go ahead.
Hi, can you hear me?
Yes.
Yeah, good. Thanks for that, Enrique. It was a really fascinating presentation. I almost missed it. I'm glad I didn't. So my question to you, and I don't know if this is something that you were planning to address and you just didn't have time to address, is that obviously because of all the criticisms that have been leveled at international investment law and in particular ISDS, criticisms that you outlined already, what we've seen in the past decade or so is a growing contestation of this regime. And that contestation has manifested itself in various ways. Some countries like the EU and Canada proposing this multilateral investment court. It's quite controversial. We've seen countries coming up with their own model BITs, which propose specific solution like exhaustion of remedies. I don't know Indian model BIT is a good example of that. And of course, others have gone for the nuclear option. Like, was it Bolivia and Venezuela left exit, Ecuador as well, but they came back. I'm not completely au fait on it. But my question then to you was, I was wondering where you stand on this. So what do you think is the way forward? And do you think, based on what you discussed early on, that the economic evidence is that these agreements do very little? Is the problem not the regime, but its existence? And is it a question of just doing away with international investment law altogether, or are you more on the side of reform? Does that make sense?
Totally makes sense. And yes, so the last chapter of my book, I argued that I present all the reforms that are happening right now. So there are like reforms at the exit level. So there's reform about the procedure within the exit international center for investor state disputes. So it's part of the World Bank. And for instance, some of the reforms are that are aiming at allowing third parties to participate. For instance, right now, if an indigenous community feels that an award may affect their interests, they're not entitled to participate. They could request to participate with amicus curiae, but the arbitral tribunal is not obliged to accept that. So there are reforms going on within exit. There are also, reforms in terms of UNCITRAL about how to avoid conflict of interest. Plus, most developing countries are also writing their own BIT models. For instance, Colombia drafted a BIT model that intends to protect their regulatory capacity. And of course, we have these examples of CETA and the European Union. Now, what I argue is that basically international investment law is an autopoietic system that all these reforms just try to are not deep reforms. What they're trying is to answer some of the criticisms while maintaining the same logic and the same ethos of the system, right? So, for instance, there are now change about, for instance, imposing outcomes or some obligations on the investor, right? So if the investor wants to sue a country, then they need to show that they have contributed for development or something like that, right? Or they're not really evident reforms about, for instance, what happens if a country like Colombia is undergoing a transitional justice reform. If there are laws that may affect the interests of the foreign investor, could the investor or the tribunal just say, well, there is no legal grounds for your claim? So what I'm saying is that a lot of those changes are just autopoietic in the sense that the system itself, in order to survive, is just making changes, but not deep changes. Now, my standing on this is either the system makes deep changes, changing totally its ethos, or the system should stop existing, right? But of course, we know that the second option is not possible. I mean, there was actually, that's counterintuitive, that during Trump administration, there was the time when there was a lot of opportunities or a lot of discussion about the existence of this system, right? Because we know if the USA actually withdraw from all these treaties, that's it, that's the end, because the biggest economy around the world. But then, if that is not possible, that second option, my standing is perhaps we should focus on making deep changes and not just these cosmetic changes that we're witnessing right now, that only their aim is just to maintain the system and to pretend that they're listening to the world, but they are not, and to pretend that they will guarantee the regulatory powers of the states when they are not. That's my standing there. I know if that answered your very difficult questions, Billy. Because yeah.
No, it does, and I agree. I've always wondered though, what. I'm sorry, maybe the other people want to ask questions, which is so.
No. Go ahead, Billy.
Just to follow up, I've always wondered what would be the legitimacy of a regime where all the empirical evidence suggests that the outcomes it's intended to achieve are not actually achieved, because we all know what international investment, the investment law system is about. It's about giving privilege rights to foreign investors, right? That's the fundamental aim, and which is hidden, because in terms of promoting foreign investment, that's not really, there's very little economic empirical evidence which confirms that. So I've always wondered how you can justify the legitimacy of an international regime which is so contested. And so, I mean, I agree. For me, it's a system that is struggling to justify its continued existence. But again, I agree with you that the reality is that we're probably not going to achieve even the deep reforms that you're calling for.
Yes, indeed. And this is very interesting because, for instance, agreement like the CETA only contribute to hide the reality of the system because they are usually presented as like the solution. Or, for instance, the BIT models, right? So Colombia has a wonderful BIT model that never uses, right? Because if you're Colombian, you're going to negotiate a treaty with the United Kingdom. I mean, you're on a very unfair and unbalanced position. So Colombia spent years on this wonderful BIT model that never uses, right? So it's like, okay, well, but it sends the message that the system is changing when the reality is that it is not. And that only helps to continue encrypting the system and hiding this all these issues behind the system that, of course, at the end facilitate systemic violence.
Thank you, Enrique.
Thank you, Dolly.
Thank you, everybody, for those questions, Enrique, for giving such robust answers and analysis to all of them. We're just nearly at 5 o'clock. I know people have got other meetings and even some teaching they have to go to. So I think we'll just close up the talk now. Enrique, thanks so much for such an engaging talk, and I encourage people who haven't done already to read his book. I think it's an area of law, cuts across so many things, whether it's human rights, transitional justice, environmental law, private law. It's a whole range of things that this area cuts across, and I know I'll be citing it in my own work. So again, thank you, Enrique, so much. It's great to see you, and it's great to hear more about your work. So thank you for taking the time today, and thank you everybody for joining us. I really appreciate it. This seminar is recorded and will be available soon on our YouTube page, so you can catch up if you missed bits of it later on. So thank you again, Enrique, and I've seen some people are clapping there.
Thank you all of you, and hope to see you very soon. Thank you all.
Yes, keep well. All the best, everybody. Thank you, Enrique.
Bye-bye.